All right. Good morning, everyone, and welcome to our workshop entitled True or False: Common Misconceptions of Estate Planning. We are so happy that you've decided to join us today, and we can't wait to provide you with exclusive information and resources that will give you a deeper understanding of us and our services. My name is Emily, and I'm the Marketing Director for Clinkscale's Elder Law Practice out of our main office here in Hays, Kansas. We also have another main office in Wichita, and we serve clients throughout the entire state of Kansas. I would like to invite you all to type any questions you may have in the chat box that's located at the very bottom of your screen. And then at the very end of the workshop, we will address any of those questions or concerns that you do have. Today, we have attorney and partner Jenny Walters presenting this information. Jenny has been with Clinkscales over 10 years and is a member of the Ellis County and Kansas Bar Association. She's actually the president of the National Academy of Elder Law Attorneys, and she's also a member of the Kansas Women's Attorneys Association. So now, without any further ado, I'm just going to go ahead and hand it over to Jenny to get us started this morning.
All right, thank you, Emily. And Emily, I may have you let me know if there's anything in the chat. If I have my screen shared, I'm not seeing that I can see that. So just let me know.
Perfect.
And if anybody has a question as we go along on any of the topics, please feel free to just put it in the chat box. Emily will bring it up. Happy to answer questions as we go, as things come up. If they come to your mind, just put it in there. And I'm hoping this is going to be just a conversation about these different topics. I have been with the law office about 11 years. And so I hope we could make this somewhat entertaining. It's not a super entertaining topic, but I do find that common themes come up as I'm visiting with people. And I wanted to put those together to hopefully give people a good idea of how general estate planning works, mainly focusing on wills and trusts and that kind of thing today. So what I've done is put together some of those topics and kind of in a quiz form. You can answer to yourself whether you think something is true and false, and then we'll talk through it. And again, if you have questions or something doesn't make sense, we have a specific situation, don't hesitate to ask. So first one, true or false? We're going to start easy here. I should have a will to name beneficiaries of my property. And I'm going to assume everybody's thinking, well, duh. Yes, I need that. Again, we're going to start easy. True. And we're going to get into the details of this, of why, because I think everybody understands a will names beneficiaries. Some people don't understand that if you don't have a will, and property goes through probate, and we're going to get into how that happens, how property goes through probate. It goes into something that's called intestate succession, which is according to the law, your assets go half to your spouse if you're married and half to your kids. And so it is really important that if you want your spouse to have everything, if something happens to you, that you have that in your will. So in case anything does end up in probate, it's going to go to your spouse. In addition, and we'll get into this also, having a will allows you to plan for contingencies. And I tell people I get all worst case scenario on them. If somebody is predeceased you, if somebody's disabled, if you want something held in trust, you can control how that inheritance happens rather than just dumping things in people's lap. But the first step is just to get your beneficiaries named, and then you can get into those details. Okay, I do not need a will. Everything will just go to my spouse anyway. True or false? That is very false. And this goes back to what I mentioned about that intestate succession. If you don't have your spouse named, and if you don't have your spouse as a beneficiary, like on a bank account or a life insurance policy, or if you don't own real estate jointly with your spouse, and if you don't have a will, it's going to go according to the law, which is half to your spouse and half to your kids. And then you hope that your kids are going to give them back to you, that spouses, if you need it. This happened actually with my own family. My grandparents didn't really share information, didn't want to at least talk to me about their plan while they were both alive. My grandpa passed away. There were some oil royalties that my grandma needed. And my dad and my uncles had to sign their half of that back over to her because she inherited half of them and they inherited half of them. So they were getting half of her oil income, which was really important to her to live. So we had to do all the paperwork to transfer that back to her. And if they would have just named a beneficiary, that could have been avoided. It all worked out, but that works out if you have a family that's going to get along and give things back. In addition, there is a little piece of this where your spouse will get something. They will get that half because Kansas law actually says that if you've been married over 15 years, your spouse is entitled to half. And so even if you try to disinherit your spouse, let's go to the opposite way and assume that, well, I don't want to leave anything to my spouse. You can't do that because under Kansas law, that surviving spouse can actually force that elective share and at least get half the assets. But if you want them to get everything, you can't assume that is going to happen. True or false? I have a will, so my property will not go through probate. And this is probably the number one most common misconception that I run into. People feel like they've done a great job getting their will in place, and they have. Just having that will is a great first step. It's not a fun thing to do. Sometimes you feel like you're jinxing things, but you just got to get it done. But understand that just by having that will, that doesn't mean you've actually avoided probate. It does mean that you've named your beneficiaries and you have that all in writing. However, this is false because it all depends on how your property is set up. And probate happens when I like to think of it as something is left in limbo, meaning, let's say you have a bank account that's just in your name, or you have some real estate that's just in your name. If something happens to you, it's kind of left in limbo because there's nowhere for it to go. Compare that with life insurance, where you generally always have a beneficiary named. Sometimes people put pay on death beneficiaries on their bank accounts. So that's an automatic thing. You have somebody named for that property to go to. And so you just send the life insurance company a death certificate, you take a death certificate to the bank, the property is going to transfer. But if you have a house that's just in one spouse's name, there's no automatic transfer. There's nowhere for that house to go. And so it has to go through probate to get the title transferred to the beneficiary. So having a will is great because it means that you've put in writing who your beneficiaries are, but you have to go through court and hire an attorney and do all the steps and the paperwork to get it actually transferred. And so to avoid that, you can have a joint tenant on your property, you can have beneficiary designations. There's something called a transfer on death deed you can do for real estate, or you can have a trust. That's kind of the very simplistic explanation of how you avoid probate. And we'll get into the details on that a little more as we go. True or false? Property will always go to the beneficiaries named in a will. I think you might be getting the hint on this, that is false. Because, and this is another common misconception, well, I have these people named in my will, it's going to go to them. If you have, let's say you have 3 kids named as beneficiaries of your will, but on your bank account, you have one of your kids as a joint owner or beneficiary. That money in that bank account is going to that joint owner or beneficiary. Your will does not matter because those beneficiary designations are going to supersede what is in your will because it's an automatic transfer to that person. And remember that your will only controls things that end up in probate. And so it's only going to dictate what happens to property that doesn't have a beneficiary and ends up in probate. So sometimes things can end up unfair because just as a convenience, people may add a kid as a joint owner on a bank account to sign checks and then realize that that actually means that that kid is going to have all of that money upon death. And so there's some better ways to do that, but that's the big picture of how that works, beneficiary designations versus who gets property through your will. True or false? A will is only to the named beneficiaries of my property. That is false. There are some other things a will can do. The most important being naming beneficiaries of your property. However, if you have minor children, another very important function of the will is to name who should be the guardians of those children if you pass away. And that's the only place you can make that designation. So then if a court needs to appoint a guardian, your will is going to say exactly who that person needs to be. And we've also talked about how, in addition to just naming your beneficiaries, you can put in contingency provisions about if somebody's predeceased you, if somebody's disabled, if you don't trust your kids and you want to hold it in trust, or there's some, they have some financial trouble, you can add in all of those provisions to control how property is actually distributed. And then another level to that is that in our documents, we have contingency provisions that protect property for a surviving spouse if that surviving spouse happens to be disabled or on government benefits or in long-term care. Because most of the time, if spouses have wills, they're going to leave everything to each other. However, when you get to a situation where you're dealing with long-term care, you're dealing with disability, it doesn't make sense to dump property in that spouse's name if it may have to be spent on care, if it may kick them off Medicaid. And so we put in contingency provisions where if that happens, that spouse will be entitled to half the property, because we talked about how Kansas law says a surviving spouse is entitled to half if you've been married over 15 years, but the other half we can set aside, protect, and either put it in a trust for them or give it to the kids. But we can protect it so that it never has to be spent on care. True or false? Probate can be avoided. Hopefully an easy one here. That is true. And we talked about how you can do that with beneficiary designations. Usually on life insurance, you've already named that. You can name beneficiaries on your bank accounts. You can name beneficiaries on your investment accounts. You can name beneficiaries on your vehicles. You can do a transfer on death deed for real estate. There's a way to name beneficiaries on basically every type of property. Each piece of property may have a different way of doing it, but the big picture is you can do it. Another way to avoid probate is if you have a joint owner on an account or on some property, joint ownership with rights of survivorship. So if one person passes, the owner becomes the survivor. And also a trust. And we'll get into a trust, but a trust is its own separate document like a will, in that it describes all the ways you want your property distributed. It describes who you want in charge of that distribution and all those contingency provisions, but you can do all that and not have to go through probate and have a court supervise it to get it done. True or false? Probate should always be avoided. False. There are some, I would say 85% of the time we want to avoid probate. It's a pain, and for the client, it's more attorney's fees, and for the family, it's headache and waiting for a creditor period and putting notice in the paper. And it's just, I feel like it's just kind of a pain and you can avoid it. However, there are some situations where it is a good and necessary thing. The first one being that situation where I talked about we can protect property for a surviving spouse. If we set up a trust for a surviving spouse and have that property protected, that has to be done through a probate. And so sometimes we intentionally set things up that way, knowing we're going to end up in a probate, but that's okay because we're protecting half the assets. The other situation is maybe you just have a family that doesn't get along. You have somebody that doesn't have full capacity to change their estate plan, and going through probate and having some court supervision is a good thing, because you know things are going to be done right. And if people want to argue about it, they're going to do that in court, and there's just going to be some oversight on that. So there are some situations where people already have a will. We just leave it alone because that's the best fit for that person. True or false? I have a will, so I never need to look at my estate plan again. I'm done. And that may work. And that's probably the simpler solution because it's not fun to look over that stuff and redo it. However, life changes. You may have your will and it's a great tool for the period of life that you're in. But again, if you get in this situation where if you're married and somebody starts needing long-term care, if you have a child that becomes disabled, if you inherit property and now want to set it up to avoid probate, you need to look at that stuff again and decide if it's still the best tool for the stage of life that you're in. Forgot to hit my button on there. So that was false. And like I talked about, the family changes, probate avoidance, and spousal protections, because there may be a period of your life where probate's okay. You know, younger people, just get a will in place, name your guardians of your little kids, and you're pretty well set for a while. But there may be a time period where you've built your assets up and you decide, you know, maybe time to do a trust because I want to avoid probate. I want to make sure my family doesn't go through that. And so you get things updated. True or false? I need to disinherit my disabled beneficiary. And this has come up for me that people feel like if they have a child that is disabled on disability benefits, and to be fair, they don't want to kick them off those benefits. They want to protect assets. So they think, well, maybe I'll just leave that child's inheritance to their siblings, and then they can take care of them. But actually don't have to do that. There are ways to protect an inheritance for a disabled child without disinheriting them. You can leave their inheritance in what we call a supplemental needs trust, meaning the property is held in trust for them, for their benefit. It can be used to supplement their needs, but it's protected from being spent on healthcare and kicking them off Medicaid or any benefits they may have. And so it's a way to shelter that asset, but still have that earmarked for them and not rely on other siblings to take care of them. True or false? A will can protect assets from long-term care costs. That is true. And that's where, like we talked about, if you have a disabled beneficiary, you can set aside their inheritance in a way that is protected from being spent on their long-term care so they can qualify for Medicaid. And we've also got those spousal protections that if a surviving spouse is disabled or on benefits, we're not dumping everything in their lap. And so we're not spending everything on long-term care. True or false? Trusts avoid probate. I think I already gave the answer to this. That is true. So a trust is, you can think of it as its own kind of little entity where your assets are held. Either you change the title to be owned by your trust, or you change the trust to the beneficiary, and your assets flow through that trust, and your trustee, which is like an executor, only a trustee is in charge of a trust, distributes your assets, has to follow what the trust says. You have all the contingency provisions in there, and you can do it without having to go to court for anything, hopefully. Now, you may end up in court and in probate if you don't set up your assets correctly, because even if you have a trust, if you don't change the title to your assets or set things up correctly, your trust doesn't control it. You get thrown in probate. And so just as important as having a trust is setting up your assets, we call it funding, to go through your trust and be handled by your trust. You need a certain amount of property to need a trust. And this is a common question for me. Well, I don't have much. Do I really need a trust? Is there a certain asset limit? And when I visit with people, it's not about the assets. So that's false. It's not about the assets. It's about the goals and their family and the needs. Because it may be that you don't have a lot of assets, but you know your family is not going to get along. And you also don't want to go through probate, and you know who you want in charge. So we may set up a trust, even if there's not a lot of assets, it's going to make sure that the person, somebody's in charge, and it's all very clear who it goes to. Because if you want to avoid probate and just name beneficiaries, that's great. But what if you have funeral expenses? What if you have other expenses, or you have a house and the utilities need paid until it can be sold? If you've named beneficiaries, you're relying on those beneficiaries to get along and split the costs and take care of things. Where if you have a trust, that property is going to be held there until it's ready to be distributed to the family. True or false, trusts protect property from Medicaid. And this is a common one, and sometimes unfortunate if I have somebody with a trust and they assume that their property is protected. Because this is false, not always, because it depends on how the trust is set up. If it's irrevocable or revocable, you can think of there being two basic types of trusts. I'm really simplifying it. They're either irrevocable, meaning you put your property in, then you put the property in and you can't touch it again. The idea is to protect it from Medicaid, from creditors. A lot of times we do this with farm ground. It's subject to the 5-year look back period for Medicaid, but it's a way to protect assets. Versus a revocable trust that you can change, you can revoke, you can put assets in and out of it. You have full control of your property. It is not protected from Medicaid. So it's a great tool to avoid probate and all the other things that we talked about, but it does not protect assets. You have to move to another type of trust to truly protect things. And then it also depends on the powers within the trust. I've greatly simplified it by irrevocable and revocable, but it really all depends on what the trust actually says and what the powers are within it. True or false, if I forgot to name a beneficiary or have a joint owner, property will always be probated. So we talked about how to avoid probate. You got to have beneficiaries, or you got to have a trust, or property is going to throw into probate. However, this is not an always, it's false, because Kansas law says that if your assets are under $40,000, not real estate, this is called its personal property, which ends up basically everything else except real estate. If the value is under $40,000, you do not have to go through probate. You can use what's called a small estates affidavit, where somebody signs off that they know who your beneficiaries are. And then let's say you have a bank account. This happens a lot. You have a bank account, you forget to name beneficiaries on it. If it's under 40,000, we can use this small estates affidavit, get it to your family. Sometimes refund checks come in from insurance and the bank won't let you deposit them. Well, we can use this affidavit to get it reissued so then it can be deposited. But again, it does not work for real estate. So if you have some little tiny lots in a tiny town, it doesn't work. You're going to have to go through probate for that stuff. So it's really important that if you have real estate, to make sure you have that set up either with transfer and death deeds or a trust, and sometimes a will, but just depending on your goals. Don't assume that you're going to avoid probate on that stuff. True or false? This presentation is over. That's true. So any questions come up? Feel free to put them in the chat box for Emily.
Jenny, we do have one question here. This person wants to know, should I go ahead and name my kids as the beneficiaries of everything?
That's a good question. It does avoid probate. It does simplify things. Ideally, you would have a conversation with an attorney to talk about if that's the best plan. Again, just in case you're dealing with somebody that's disabled, or a special circumstance, or a trust makes more sense, or you're wanting to protect assets with an irrevocable trust. But a lot of the times I'll tell people, we'll have that discussion, and then we'll decide that naming beneficiaries does make the most sense. And so they'll do that and make sure everything is set up to avoid probate that way.
Perfect. Thank you for answering that question, Jenny. I do not see any more questions in the chat box at this moment, but now's your chance. So please feel free to add your question now as we go ahead and wrap up our presentation this morning. Okay, well, perfect. That was great timing. Okay, so this question is, as a 50-ish person, we have been trying to figure out where to start the whole will and trust. Let's talk about this, Jenny. This is a good question. Do you take
Yeah,
appointments to meet and advise people? How do you get started?
that is it. I'm so glad you asked that. So the way we do it is you would call the office. We have a really nice girl named Macy that would get some basic information from you to decide, first of all, if we can help you, if it makes sense, if we're the best fit, and then she'll schedule an appointment. And that's when we'll talk through the plan and decide what's the best fit, what the plan should be, what your goals are. And that point is when we have a meeting and advise you and then go from there.
Perfect. And actually, that's a really great segment into what I was going to say next. So I do want to remind everyone that you will actually receive a follow-up email that will contain a few important things. That email will include a recording of the session, and we provide that to you so you can share it with other family members, friends, colleagues, anyone that wasn't able to make the session today, or so you can just go back through and take notes on all of the important things that Jenny covered this morning. The second thing the email contains is a SurveyMonkey link, and I'm putting it in the chat box right now. So it's in the chat box, okay? And all you need to do is just click on that link and fill out a quick two-minute survey. It'll take you about 2 minutes. And so from that survey, you'll receive a completely free consultation, okay? So we call it a strategy session because you will leave that consultation with the strategy, with what to do next. Okay. And so you get to speak with one of our attorneys about your unique situation. And you do that from clicking on that survey link. You're also going to receive a free book that one of our other attorneys, Randy Clinkscales, co-wrote, called What You Really Need to Know for the Second Half of Life. And that's a great book to talk about some of these estate planning topics that Jenny mentioned this morning. So I want to reiterate that you can call our office anytime at 877-325-8040. If you have questions regarding the free strategy session or any other questions in general, we're always happy to chat. And then I would also like to invite you to stay up to date on all of our upcoming workshops that we have. We do have another workshop coming up on May 3rd, where Randy will talk about how to help your parents and grandparents pay for the second half of life. And plan for that second half of life. So he'll talk a lot about how to have those tough conversations and ways to be sure that they get the best care possible. And I'm putting that phone number in the chat as well in case you need to reach us.
I'm seeing 2 more questions.
Perfect.
If my only child is named as transfer on death, but my will states that the proceeds of the sale of the house are to be distributed to my son and 2 granddaughters who are not his children, will that need to go through probate? That's a great situation. And if I'm understanding it right, if you have the house as a transfer on death to someone, that house is going to become theirs, and it does not matter what your will says. And so if you want your will to take care of what happens to those proceeds in the house, then you do not want a transfer on death beneficiary on that house, because again, it's going to go to that person. This is where those transfer on death beneficiaries supersede your will. And so it's going to depend on how that is set up. If your house does not have a beneficiary and ends up in probate, then yeah, your will is going to dictate what happens and how the proceeds are divided. But if it's set up to avoid your will's not going to cover it. I hope that helps clarify that. And then question about if we come out to other communities and speak. Fortunately, yes, we are starting to do that again. And so if there's, Emily can probably better answer that on how we would handle that, or just reach out and she'll.
Yep, that's a great question. Glad you asked that. We do come to different communities, facilities. I'll bring one of the attorneys with me and we'll just talk about whatever topics, whether that's Medicaid, Veterans Aid, how to pay for long-term care, estate planning, essential documents, anything like that. We're always happy to talk with you about that and bring some information for you and your clients or your coworkers, however that works for you. So you can also fill out that SurveyMonkey link and just leave a little note that says that. So that link is in the chat box and it will be sent out in an email. So yeah, just reach out to us and we're always happy to work with you on those opportunities. Jenny, I don't see any more questions here on my end.
Nope.
So with that, we're going to go ahead and just close down. And I want to thank all of you for being in attendance this morning. We really hope to hear from you soon. Please fill out that SurveyMonkey link and let us know of any questions. Thank you so much for your time, Jenny, and for putting together that great information for us all.
Thank you. Thank everybody for taking their time. So, okay. See
Thanks.
ya.
Have a great day.